welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest today is Michael Jones, who's also a CPA. Michael is a partner at Thompson Jones LLP, a husband and wife partnership located in Monterey, California. His tax consulting practice focuses on sophisticated wealth transfer strategy, trust and probate matters, and family business transitions. And I can tell you that Mike is the CPA that top estate attorneys go to with their tax and litigation problems. So he's a very high-level CPA, and I'm very excited to have him here with me today. He is the author of a new book, Inheriting an IRA. And he's also wrote another book called Guide to Electing Out of the 2010 Estate Tax, which is a sort of a past historical note now. And then he's also written Final Regulations Governing Minimum Required Distributions, a special supplement to the Pension Answer book. And he's the author of over 100 published articles and serves as the chair of the Trust and Estates Magazine's Retirement Benefits Committee. Mike knows something about retirement benefits and estate matters. He's also been quoted in the New York Times, Forbes magazine, the Wall Street Journal, Bloomberg Financial Report, and others. And he speaks at major CPA events and for estate planning councils and other estate gatherings. He's an avid prone paddleboarder and surfer. So Mike tells me he's just getting ready to get together with a group, and they're going to paddle from Catalina Island to the mainland. Wow, that's going to be quite something. I can tell you also, Mike provided some invaluable comments to my own book, which is How to Use Roth and IRA Accounts to Build a Secure Retirement. And I understand that he's in the process, well, like I said, he has finished, yay, his own book about handling these accounts after death. Mike provided invaluable comments, Today we're discussing community property issues for retirement accounts. So we're taking on a really challenging area. So I'm going to caution you, we're only going to hit some highlights, but what we're trying to do is to alert our viewers about things that they should be aware of and to discuss with their own attorney, their own tax advisors. I also want to mention that only 10 states, including California, have community property laws, and the rules vary. They each have their own flavor of community property. So Mike and I are California CPAs. We're going to be mostly thinking of things as they relate to us here in California. Be aware that things may be a little different in your state. And we are not lawyers. We don't claim to be lawyers. So again, get your own qualified tax and legal counsel for your own situation. Our main message: estate planning and administration are not do-it-yourself jobs. It's essential to work with a knowledgeable attorney and tax advisors. Mike, thanks so much for joining me today.
Thanks for having me.
Well, Mike, okay, let's take it from the top. What the heck is community property?
Well, property rights, my lawyer friends tell me, are a matter of state law.
Okay.
And in these community property states, the state law is that anything that you earn during your term of your marriage is owned half by each spouse. So really, community property is pretty much a 50-50 proposition.
In other words, the husband and wife are each considered as owning a half share in the totality of this property. Okay. And now also we go beyond husband and wife, because now we've got same-sex married couples and we have registered domestic partners. These people in California enjoy the same rights as traditional married couples.
That's true, and you and I, of course, are both involved in the tax aspects of those things. The IRS has followed Supreme Court precedent and said that yes, they're going to recognize those forms of community property in each of those kinds of relationships you just mentioned. The IRS has a publication 555, which talks about community property and does touch on those subjects.
Great, thanks, Mike. Why is the status as community property important?
Well, it has to do with your property rights when mostly what I do is estate planning, so what property rights exist on death. And of course also has to do with when marriages unfortunately sometimes terminate. And when they do, we have to consider the community property rights in the divorce and somehow divide those things up. It doesn't mean that you have to divide everything when you're making a disposition of your property at death in every last property in half. You can aggregate everything and kind of go by value and give marbles to Susie and jacks to Jimmy.
There you go. Okay. Now, related to that, of course, there should probably be some language in the will or trust giving the executor or trustee the power to do that sort of thing.
That's correct.
Yeah, okay. So
It also gets to the question
yeah,
of what's includable in someone's taxable estate.
yes, okay. Now, there's another form of property that you and I were talking about yesterday that called quasi-community property. So maybe you can tell us a little bit about that.
We don't see that come up as often, but it certainly can come up. It comes up when somebody moves here from another state while they are married. So let's say, for example, that my wife and I had gotten married in Minnesota, which we did.
Okay.
And let's say that we spent most of our working years there in Minnesota, contrary to actual fact.
Okay.
But then about the time we got somewhere near retirement, we decided to come out to California. And by then, let's say that we had acquired quite a bit of property. Well, all of that would be separate property. Deanne's property would be hers, and my property would be mine, because Minnesota is not a community property state. However, when the first of us dies, I have to remember how this works.
Okay.
There is a right to receive half of what would have been community property had we lived in California. And I have seen this come up recently with a very large individual retirement account that was earned by the husband while they were still living in New Jersey. And when they moved out here to California, he had a very substantial set of IRAs. And when he died, half of that was quasi-community property, and therefore his surviving spouse has a right to take that on death.
Why is community property especially complicated for retirement accounts? Now, I know I'm opening up a huge can of worms, but just sort of give a succinct response as you can, and we're going to go from here, of course.
Well, let's start with the IRAs and work our way into the more complicated things. With the IRAs, there is sort of a two-headed monster to deal with. It's community property in that each of my wife and I essentially have the right to half of the other's IRA. That can get complicated when one of us dies because the IRA ostensibly is controlled by a beneficiary form that I can fill out for my IRA that says when I die, my IRA goes to, let's say I decide to leave it to Santa Clara University, a law school, for example.
Okay.
Jerry Kasner Fund.
There you go.
Just to mention one.
Okay.
And Deanne can raise her hand and say, wait a minute, that's 50% community property and I have a right to that. And so what will happen is that the IRA custodian will say, gee, I'm not sure what to do with that. Why don't you and the Santa Clara University go to court and figure that out?
Oh boy.
So, and Deanne will probably win, but that's kind of one aspect of community property. Right. The other aspect of community property that makes it a little bit complicated with an IRA, as well as with a qualified plan, is that, well, the community property would be includable half in each estate when someone dies. So that means that if Deanne were to die first, her community share of my IRA is going to be part of her taxable estate. Now, I may get that, so there's a marital deduction, but still it's got to be reported. Divorce purposes, again, you get to split. Now, on the IRAs, There's often something that says that if I were to name Santa Clara University Law School as my beneficiary, Deanne could possibly consent to that, and therefore supposedly then she's saying, well, that's okay with me. Not necessarily going to work. It can actually cause problems if she doesn't have separate counsel and can carefully consider that she's giving up valuable property rights. So I've seen situations where even though a spouse has consented, it goes to the spouse anyway. So that can get complicated.
Okay.
The next thing that gets complicated is with the plans that are offered by employers. Many of those plans are covered by the Employee Retirement Income Security Act of 1974. And there are two aspects to that that are very important. I hope I'm not jumping too far ahead.
That's okay.
It's probably as good a time as any to go into that.
Go ahead.
So one aspect of it's called ERISA.
Mm-hmm. It's the nickname.
It's the nickname.
Okay.
It's the acronym. And so ERISA has a provision that basically makes its plan provisions trump kind of anything else you do in estate planning.
Mm-hmm.
So ERISA basically says that the rights to a plan on death or during lifetime can't be alienated or assigned, which means they're creditor protected. But it also can mean that the beneficiary can't be challenged. And we've seen that come up in some cases I know that we'll discuss a little bit later.
Yeah, or maybe even in another program.
And the other aspect of ERISA that is in 1984, we got the Retirement Equity Act. Geraldine Ferraro at the time was running for vice president, and it was said that this was penciled in, I think, on the campaign trail. So it's also called the Geraldine Ferraro rule.
Okay.
But it says that every ERISA-covered plan has got to offer, on a required basis, must offer at least a joint and survivor annuity to the spouse, and that's also indefeasible.
Now, for the sake of brevity, in the divorce context, retirement plans, including employer plans and IRAs, can be community property, and there are special provisions for dividing these accounts without generating taxable income. That looks like that's a point that got turned into, I thought it was going to be a question. Okay, well, anyway, just, it's a point, though, that we have, I guess as a reminder to our audience again, that, and maybe you could elaborate on that a little bit. So, in other words, as I understand it, there are ways that we can divide these without having to create a taxable income situation in the event of a divorce and so forth.
That's true. And the proper way to divide that is to set up, again, let's assume that unfortunately Deanne and I were to decide we needed to terminate our marriage. And if she were going to take half of my IRA, the way to do that would be for her to set up her own IRA and then make a direct transfer from my IRA to hers.
Right.
Now, she could roll it over if there was a distribution, but the safe way is to make the money go directly from one person's IRA to the other so you don't wind up with a problem. There's a case, if I may bring it up, the Bunny case that I know we had on our agenda to speak about.
Okay.
And in that case, Michael Bunny was directed as part of the marital settlement agreement to give his ex-spouse a part of his IRA. So he took the money out of his IRA and gave it to his spouse, who failed to complete the circuit by making the rollover, and he had to pay the income tax on that. And here's why. Although the Internal Revenue Code, when it defines what an IRA is, essentially recognizes that there is this thing called community property. It says that for purposes of administering that part of the Internal Revenue Code that gives us IRAs, that we're going to ignore community property. And the tax court in the Bunny case said that that means that even though Mrs. Bunny had the right to receive those funds, and the marital settlement agreement said she was going to get those funds, and it was community property, nevertheless, because you ignore community property for purposes of the Internal Revenue Code section that defines IRAs, Mr. Bunny had to pay the income tax on the distribution. Pretty unfortunate result, but that's how it works. So there's a sort of split identity between recognizing community property in terms of property rights, but not for purposes of who pays income on distributions and who pays the tax.
It's kind of crazy, isn't it?
It is.
So, but what we're saying in essence is because it was Mr. Bunny's IRA account that made the distribution, that in fact, that's the reason why he ended up paying the tax on it, because it wasn't made as a direct transfer. And it reinforces the idea that you were saying before, that in most cases we're better off with direct transfers related to these, because it just avoids a lot of issues. I mean, well, there's a recent one even that's come up as a development, and that I know that you know about, and that is, whether you could in fact make rollovers from separate accounts within a year. And of course, the tax court recently said, no, you only get one rollover a year, period.
Yes, that's the Bobrow case,
Yeah.
B-O-B-R-O-W, and the IRS is going to enforce that. It's going to issue new regulations having to do with that. But they did say, we understand you all need some time in order to comply with that. So we're not going to enforce the one rollover per year until 2015. So if you did that last week, you may still be okay.
Yeah. So still, it's not a comfortable position to be in, because the Internal Revenue Code says one a year, and that's why the tax court ruled the way that it did. And then there are also special rules related to retirement accounts in general, where you have to get a special type of order for like an employer type plan, quadro.
So that implies, that does apply to an employer plan.
Right.
And when there's a divorce and a marital settlement agreement, the quadro basically means that the surviving spouse is going to get payments from the plan and will pay the tax on those distributions. We don't have those with IRAs. We only have those with employer plans.
Well, we are sort of talking about retirement accounts in general.
Right.
Mostly Mike and I focus an awful lot on IRAs. So anyway, but I just wanted to remind people. So there's no such thing as a quadro for an IRA.
No.
But there is for employer plans, and you want to be sure that you dot your I's and cross your T's when you're handling these things. Again, this is not stuff that you try to handle on your own. You definitely need to be working with a good attorney on this. Maybe you could talk to us a little bit. You sort of alluded to it before, but maybe you could talk a little bit about the Boggs decision, which was a few years ago now, and its impact on estate planning and administration.
Boggs was a case in the Fifth Circuit down in Louisiana. The Fifth Circuit Court of Appeals, which is the next court just below the Supreme Court, so pretty good authority. And it stands for the proposition that I do not, when it comes to an employer plan, I do not have the right to make a testamentary disposition of my community property interest in my spouse's retirement plan account. The facts are rather complicated. I won't go over them here, but it basically says, is an example of where of a qualified retirement plan offered by an employer, and that's ERISA covered, can actually wind up trumping the community property rules.
Right. So in this case, I can't remember who was the first deceased spouse, but
well, Mr. Boggs' first wife died,
okay,
and tried to make a disposition of some of his plans.
Right. So she tried to make a provision in her will or trust to the effect that she wanted some of her husband's retirement account to go to somebody, maybe, one of her children, could have even been a child from a previous marriage, I don't know. But she wanted to direct it, and basically the court said, no, the language in the plan, the beneficiary designation, is going to supersede whatever you have in the will. Now, there may be other things that maybe could be done in the way of like a makeup provision or something, I suppose. But
well, that's part of the estate planning process,
yeah,
is to recognize those things and to make reasonable compensations for them and how the plan is going to be settled. So, for example, if you're not going to get the retirement money, maybe you get the house.
Okay. Maybe you could tell us a little bit about the McDonald decision.
The McDonald decision is a California Supreme Court case. So in terms of the great state of California, that's the law of the land here.
Okay.
And it has to do with, let me tell you a little bit background of what happened in that case. I believe it was Mr. McDonald who was terminally ill. And the two of them, the two spouses, made very specific plans about who was going to get what.
Mm-hmm.
And what happened in that case was that all of the IRAs were going to go one way according to all of their plans. Well, it turned out that when Mr. McDonald died, and I forget whose IRAs they were now because I didn't look at this case last night, for example.
Okay.
But there was a dispute by the children who said, "Now wait a minute, we have a right to half of those IRAs."
Mm-hmm.
And the Supreme Court said it really got to the question of whether those IRAs continued to be community property and therefore belonged one half to each spouse.
Mm-hmm. Mm-hmm.
And what happened was the Supreme Court then examined that agreement that existed between Mr. and Mrs. McDonald.
Mm-hmm.
And then when they looked at the agreement, they said, that didn't rise to the level of being what the family law folks call a transmutation.
Mm-hmm.
A transmutation is changing property from community property to separate property or vice versa.
Mm-hmm.
And this didn't get there.
Mm-hmm.
And as a result, it was still community property when Mr. McDonald died and had to be divided up in that way, even though they had worked really hard to decide who was going to get what.
Boy.
So it was rather a tragic case in terms of all the work they went to make sure everyone got the right things.
It sounds like maybe one thing that they could have done is actually divided up the accounts.
I think the correct thing to do today
Mm-hmm.
would be that if you're going to do a transmutation, you need to get your estate planning lawyers and
Mhm.
possibly family law attorneys involved.
Oh,
Who
and
will-
have separate counsel for
And
each.
possibly have. So the thing about transmutation is that when you're saying that you're going to transmute property from community property to separate property, the two spouses, economically at least, have got, in theory, a conflict with each other
Yes.
and therefore need separate representation. So you could actually sign a document that says you're doing a transmutation,
Mm-hmm.
but in a sense, if it can be shown you didn't really do your homework and make sure that both spouses were fully aware of what valuable rights they were giving up, is it going to stick? So if you really want to avoid litigation, your best chance at that is to get the separate representation, so my lawyer friends tell me.
One thing that I've seen over the years is I think that that in many respects things have become more formal in how we handle these estate planning matters. I think that there at one time could have been much more informality in what people would do, and maybe they weren't as litigious in those days, so they could sort of get away with it. But now it seems like, well, let's just say there's a lot of good attorneys out there that are doing some very good marketing these days. So now you really want to, again, be sure that you have your documents in really good order to protect them from these types of disputes.
Yeah, and I think you want to be able to show that you've gone through a process where everyone had a chance to really understand what their rights and responsibilities were and to make informed choices about the documents that they are signing.
Should a non-participant spouse's will confirm the participant spouse's interest in an IRA, and why?
Well, let me go through how that breaks down, and
Okay.
then I think we'll see what those answers are. Because my spouse has a community property right in my IRA, it is possible that upon her death, she would be able to take that half of my IRA. On the other hand, it's quite possible that because I have a community property interest in her IRA, that I would be able to dispose of that upon my death, even though she continues to be alive and has her name on the IRA. So I might want to consider saying in my estate planning documents, quite probably in the will, that upon my death, I confirm my spouse's interest in my IRA, meaning that I'm making it very clear that no matter what I may have done during lifetime, she has the right to half of my IRA and therefore can take that no matter what the beneficiary form says. And then I might also want to say, and I give to my spouse my community property interest in my spouse's IRA, so that it's clear that she owns all of her IRA after I have died. Those are the two mirror image things that you might want to consider putting in a will when it comes to the community property interest in the plans and the IRAs.
Okay. Let's see here. So maybe related to all of this, should there be a will or trust provision to equalize community property, considering a retirement account may be distributed according to a beneficiary designation?
So to just break that down a little bit,
Yeah.
we first want to make the point that beneficiary designations control what happens to IRA benefits. Not your will, not your trust, unless, of course, you name the will, the estate, or the trust as the beneficiary of the IRA. So generally, specifically, let's say that I want to give all of my IRA to one of my favorite cousins. And so I leave her name on there, and Deanne says that's okay, and she gets up her counsel and consents to it and all goes over there. So the question you're asking is, should there be something in my estate plan to compensate her for that? And I think probably yes. So this is why you want to have, again, a good, solid estate planning team who can help you understand not only where things are going to go, but how the values are going to settle upon the various people, so you can make compensations for these things as may seem appropriate for any particular circumstance.
Okay. Well, Mike, we're all out of time.
How quickly it goes.
How quickly it goes. So I want to thank you again for joining me as my guest today.
Thank you again for having me.
Yeah, it's a real pleasure. Just as we finish here, why don't you mention, let's see, is your new book going to be available at Amazon? Or,
so the place to go look for my new book is inheritinganira.com.
Okay.
And that will tell you about the book, quite a bit of information there. And there's a click through in there to createspace.com. It's also available on Amazon.
Okay, so you can get it at Amazon, or you can go to inheritinganira.com. That's it, folks. Thanks for joining us. We'll see you next time on Financial Insider Weekly.